law, the Academy speaks. I'm your host, Craig Peters, the president-elect of the International Academy of Trial Lawyers. Today, our topic is the public consequences of private justice. We're going to talk about jury trials, arbitration, open courts, and the rule of law. And I'm pleased to have with us today two incredible lawyers who are both in the Academy, as well as two lawyers who call Dallas their home, Quentin Brogdon and Kathy Patrick. I want to start, Quentin, with you. You wrote an article recently on law.com, and I want to ask you first, why did you write that article? What's it about? How does it relate to our topic today?
Thank you, Craig. I read an article that mentioned that UK, the United Kingdom, was considering abolishing jury trials, not in all cases, but in serious criminal cases. And it just jumped out at me as a crazy notion. If you can have the abolition of jury trials, or some of them in serious cases, even felony cases, in the modern birthplace of the jury trial, the United Kingdom, then it occurred to me that we should perhaps be considering how that could affect us here in the United States. We would say, and it's a comforting fiction to believe, we're way away from that. We're not so far down the road as the United Kingdom is. They're having some budget issues. They have a huge backlog of criminal cases. So some of what's going on in the United Kingdom arguably is situation specific. But we here in these United States, our jury trial system is under assaults from really two separate wings and places, it occurs to me. One is just indifference and misunderstanding about jury trials. And part of that is a function of civics isn't being taught in our high school anymore. There's a misunderstanding out there, an innocent one, it turns out in many cases, whether jury trials work and whether they're the cause of delays or whether they dispense true justice. But another part of the attack on jury trials is much more insidious and dangerous in the United States. And those are well-funded attempts by corporations to avoid accountability, particularly when they're sued by individuals. And so we need to be vigilant that the roots of this misguided thinking in the United Kingdom don't take root, and the seeds of them don't take root in our United States.
So let's talk for just a minute. You talk about the birthplace of the jury trial. Our jury trial system here in the United States, you're saying, is based on essentially the British system?
We inherited our jury trial system along with the common law from the Brits. And it's interesting to note that many of the countries that inherited that system have since moved to abolish it and or curtail it dramatically. We, fortunately, have not done that, other than through the proliferation of arbitration and some of the so-called tort reform that we see. It's fascinating to me that the very corporations that want tort reform in personal injury cases that limit and handcuff those jurors with respect to the dispensation of awards down at the courthouse do not want that when they sue each other. They want no so-called tort reform or verdict reform when one corporation sues another. They're perfectly fine with a jury deciding whether one corporation owes another corporation billions with the B of dollars, and they're perfectly fine with jurors deciding whether a criminal defendant should receive the ultimate penalty, the death penalty. But somehow the idea has taken root, because they've paid to make it take root, that jurors can't be trusted to decide, for instance, how much a widow's pain and suffering is worth down at the courthouse.
And so the British system gave to us at least the idea, if not the model, for a jury system. Do we have a right to a jury system? For those folks who aren't lawyers that might be watching this podcast, do we have a right to that, or is that just an option that we take and that we can opt out of?
Our right to a jury trial is enshrined in our Constitution. It's in our Bill of Rights. The Bill of Rights was added specifically so that the 13 original colonies would adopt the Constitution. And there was a concern because it was not explicitly within the Constitution until it was added in the Bill of Rights. Our founding fathers certainly understood the power and the importance of the jury trial system and the connection between jury trials and freedom. It is only through jury trials that citizen jurors, citizens of our republic, can curtail and hold our government accountable when it overreaches. It dates back at least as far back as the Magna Carta in 1215. The king signed it and said, basically, I can't put you to death and do bad things to you if you're one of my nobles unless you have a trial with a jury of your peers. And so that's, many believe, the origin, the modern origin of the jury trial. And there's an explicit connection between jury trials and the jury trial system and our freedom, our very freedom. And our founding fathers certainly understood that. Prominent within the Declaration of Independence as one of the main grievances the American colonists had against the British Crown was that the British Crown, the king, had denied the American colonists of jury trials in many circumstances. That's within the Declaration of Independence.
And so if you had to provide a summary to say a middle schooler or a high schooler about why the jury trial was put into our Constitution, what the importance of the jury trial was to our founders, and what, at least I presume you still believe are valid reasons for us to have jury trials, what would those be? What's sort of the punch list, if you will, about why jury trials are so important?
Well, everyone understands the ability to vote and to vote for representatives that govern you is important. What seems to be less understood is the explicit connection between our freedom and the ability to stand in front of a jury of our peers, whether it's when we're charged with a crime or when we've been crunched at an intersection by an 18-wheeler tractor trailer rig. There's an explicit connection, and the connection is this: only citizen jurors ultimately have the power to hold the government accountable when the government overreaches. Only citizen jurors can decide whether a widow who's lost her husband, how much that's worth, what that's worth, and whether that was caused by the negligence, for instance, of a trucking company. And so there is a very much an explicit connection between those things and between the judges who preside over those jury trials and the lawyers who try those jury trials. Both the judges and the lawyers need to be allowed to conduct their very important constitutional work in an unfettered manner. And many of us have grown alarmed in the last few years that there's been an attempt to muzzle judges and lawyers who, as part of their constitutional obligation, are simply carrying out their fiduciary duties to our system of justice and to our citizens.
Okay. So we've got citizen participation sounds like that's one of the benefits of having jury trials. The value of having people from our community determine what our community values and standards are. Perhaps something related to kind of an evening of the playing field between the really powerful and the less powerful.
Absolutely. There's one realm where an individual can become the equal of a multi-million or multi-billion-dollar corporation, and that is in a courtroom with a jury of that individual's peers. That's when the playing field ultimately is leveled. And the whole process of having jury trials legitimizes our system of justice. The perception, and it's not simply a perception, it's a reality unless we allow it to become other than a reality, is that the system works. It's that meaningful, objective justice is being dispensed. And that comes about because citizen jurors are down there every single day dispensing it.
And I guess, so that sort of leads me to think there's a fourth piece, which is that it's not only happening by people in our community, but it's happening in a public way, in a public forum, not just for those 12 or 15 jurors, if you've got alternates, what have you, but also the people that are able to come in and watch that proceeding, which then creates a record of what happened and something that we can rely on in the future when we look back at past cases. Does it sound to you like there's kind of four things we've got there?
Well said, Craig. I couldn't have said it better myself. And I know we're going to talk about arbitrations. That's one of the evils of arbitrations. There's secret proceedings. They're not legitimized. They're not perceived to be legitimate. And there's no written record created that the public can see what so-called justice is being dispensed as a result and through those arbitrations.
Kathy, this seems like a perfect time For you've done these things called arbitrations, I assume, yes?
Yes, I've done dozens.
Okay. So when you hear Quentin talk about his alarm at reading an article about what the UK is considering, and then his article sort of pushing back against that, tell us sort of your perspective as it relates to any parallels that might be in your mind between this kind of rise of arbitration that's happening while across the pond, the UK is considering decreasing the availability of jury trials.
So I think you can trace the issue to what I would call a distrust of the wisdom of ordinary people. You know, we inherited, and we have in the United States, according to the Supreme Court, the right to trial by jury as it existed in 1789. That's how it's been interpreted, as Seventh Amendment has been interpreted. To Quentin's point about the importance of the issue, it's so important they said it twice, once for criminal defendants in the Sixth Amendment and once in civil cases in the Seventh Amendment. So this was not a trivial matter when the country was founded. It was a bulwark of liberty and autonomy. But in fairness, one has to say that the complexity of the things that were being tried in courtrooms by juries in 1789 is vastly different from the things that are being tried to juries now, right? If you think about a typical antitrust case, a jury in an antitrust case is going to be asked to define the relevant product market, which is a three-part test with subparts according to a variety of Supreme Court decisions that have been reached about it. And jurors look at that and they're like, what do you want me to do with this? Right? And so the drive to arbitration began initially, and I think in fairness began initially. It arose, to my knowledge, in the context first of disputes between insurance companies over which group of underwriters were required to pay coverage, right? And so initially, insurance arbitration was where this got its foothold in the United States. It expanded from there to construction, where you wanted decision makers who actually understood what engineers did, what contractors did in building big projects. And so, you know, one of the first big arbitration cases is Prima Paint, which is a construction dispute in the Supreme Court. But what has happened in the United States is arbitration has moved from those specialized areas where one might make an argument that it's tough to ask a jury to decide those questions into areas where jurors are perfectly well able to understand, did somebody misuse data that I gave them on my bank account? Or did the phone company misrepresent a fact to me when they gave me this plan versus that plan? And so it has grown like Topsy because the Supreme Court, we all have to be fair, loves arbitration. There's not an arbitration in the case that comes to the United States Supreme Court that they don't say arbitration wins. And so I think that the genesis of that is that in the UK, you know, we were just in Ireland, Craig, and talking to a justice of the Irish Supreme Court. They don't try anything except serious felonies to a jury because they just don't think, their argument is somewhat it's beyond the ken of ordinary jurors to decide commercial cases, but also it's unfair to burden them with the obligation to decide cases when we have a judicial system that can do that. And so they try most civil cases, to the extent they're tried in the UK, not to juries, but to judges. And even in arbitration.
But I mean, isn't that fair? Isn't that why, at least in part, the UK says they're contemplating going this direction? And what we heard from the justices in Ireland, saying that, you know, look, the arbitration, it's faster, it's cheaper, it's more efficient. Justice delayed is justice denied. So isn't arbitration a good thing because you can get your justice faster?
Arbitration is not faster, cheaper, or more certain for many reasons.
Wait, they strike out on all three?
I think they do. I have to tell you.
But that's not what I've been told.
I'm not a fan of arbitration. I've done a lot of it. Here's what happened. when arbitration first started, arbitration was no discovery, fast, and over. No appeal, no law. Now what happens is in many arbitrations, you get the same amount of discovery. Now, bear in mind, Craig, I do large commercial cases. So that's where Quentin and I differ, because in my universe, if I'm arbitrating something, it's a $700 million sinkhole disaster in Louisiana or a big dispute over an energy contract where those companies want those cases to be decided with full discovery and full evidence. And so they take depositions, they do everything that you would see in a typical case. They might try to set it a little faster. But, I've had arbitration matters go on for a decade, just like a civil case. And it's because good lawyers want the cases to be decided on the merits and with full evidence and after a full hearing. And so it takes a long time. And the vice of arbitration, in my judgment, the vices of arbitration are two. Yes, you get some expertise as your decision maker, but the price for that is a process where the law does not apply predictably. In fact, it applies, if at all, in the breach, because only for clear error can you not even clear error, only for a wrongful refusal to apply the law can you overturn an arbitration award under the Federal Arbitration Act. And there's no appeal. So if you have an arbitration proceeding where you've got three people and they just apply the wrong law, there's no recourse. There's nothing you can do. And in many cases, the law matters a lot, right? In a case involving a fiduciary duty, whether those duties have been waived, whether Delaware law or Texas law applies, actually matters, and there's no recourse for that. So that's one problem. The second problem is it is very costly. I think arbitration is exceedingly costly because you are paying the arbitrators for their time. And they do not necessarily have an incentive to move the case rapidly, because if they move the case rapidly, they don't get paid. We have a system for which we've all paid. It's a judge and a jury, and that works. And so I don't think either of those things works. And then you raised a third point, Craig, which I think gets lost in the shuffle, which is arbitration is not transparent, and it's not repeatable, and it's not subject to meaningful accountability, right? So if we go try a case in a court in front of a jury and a jury makes a mistake, there's an appellate court that issues an appeal, that rules on an appeal and can correct the verdict. Or if a judge makes an error of law and she just gets it wrong and she mistakenly issues judgment when she shouldn't have, the appellate court is there to do that. That does not happen in arbitration. There's no actual way to do it. And it is such a deficit in the process that recently the American Arbitration Association, which is one of the prominent arbitration providers in the US, adopted a set of appellate rules that can be invoked to appeal an arbitral ruling through an arbitrated appeal, because people were so unhappy with what I would call the lawlessness in the loose sense, that is the inability to get the law applied correctly in arbitration.
So let's I think it might be helpful for listeners that aren't lawyers or don't know maybe some of the specifics about arbitration, what the problems are. If we can break it down, there's really two different kinds of arbitration, right? There's one where let's call it pre-dispute, and then there's post-dispute arbitration. So maybe, Kathy, can you just kind of give us a quick overview? What's the difference between pre-dispute and post-dispute?
And I would say there are two kinds of pre-dispute arbitration agreements and a post-dispute kind. So type one of pre-dispute arbitration agreements is the one that is kind of imposed on you in a contract you signed to buy a phone, or a contract you signed to rent an apartment, or to borrow money or lease a car. It's in there. It says if there's a dispute between us and the person who sold you this contract, you're going to resolve it in arbitration. And often those include not only waivers of jury trial rights, but waivers of specific kinds of damages. People call them boilerplate as though they think it doesn't matter. that boilerplate has real consequences in terms of real waivers of people's rights. So I would talk about consumer arbitration as one kind of pre-dispute arbitration agreement. There's a second kind of pre-dispute arbitration agreement, which exists in large commercial contracts. Think a big construction project, a big intellectual property license agreement where you're buying system-wide software for your business. Agreements to purchase companies are often arbitrable. Partnership agreements between large companies often have partnership agreements. Many energy contracts between large energy companies have those. And those will be often hand-tailored agreements. That is, they will write exactly how they want the arbitration to happen, what law applies, who can be an arbitrator, how it will occur. And they're negotiated between people who are on equal footing. And so those are another kind of device. Think of it just as another commercial contract where, in addition to contracting to do a business, we're going to contract for how we resolve the dispute if one arises. That has fewer vices. I still think it has vices because when you do that, you're bargaining for private resolution, a lack of ability to enforce the law, and an inability to appeal if the arbitrators get it wrong. But mostly people that are entering into that kind of large arbitration agreement understand the rights they're sacrificing. But consumers often don't. And they don't find out that they've sacrificed those rights until they need to invoke them. And then Quentin has to tell them, I can't get you into court in front of a jury because you've waived your right to a jury trial. Now, those two kinds of things are different from a post-dispute arbitration agreement. Sometimes people have a dispute and they want to get it resolved, what they hope will be quickly. And they sit down and they say, let's just go to arbitration. Let's mandate that the arbitration happen in 45 days. You pick an arbitrator, I'll pick one, they'll pick a third, and let's get this done. This is too important to wait. That kind of post-dispute arbitration agreement is also enforceable under the Federal Arbitration Act, and it can be effective to waive people's rights. I've had cases where people had a limited arbitration agreement and decided post a dispute to expand it to include other things. And so I think it's important for people to understand that there are three kinds of arbitration agreements that can happen, and they affect people differently depending on where they sit when they're signed.
So let's talk about, I want to focus on pre-dispute versus post-dispute, and I want to focus on the pre-dispute as it relates to the iPhone that I buy that says check this box if you agree, and there's a bunch of wording. And so Quentin, maybe can you tell us first, I'm a little confused. In our Constitution, Kathy just told us, and you told us earlier, jury trials appears twice. But then we heard that the Supreme Court loves arbitration, but arbitration I don't think is in the Constitution, right?
Correct.
So how is it so why would the Supreme Court love arbitration over a constitutional right for a jury trial? Can you help us understand that and
Sure.
why if there's a problem with that?
Tune in next week for part 2 of our podcast, The Public Consequences of Private Justice.